Okay, great. Let's go ahead and get started. Good afternoon, everyone, and welcome. My name is Taylor, and I am DWDC's program coordinator. And today I'm joined by my colleagues Kelsey and Amanda. We would like to begin by acknowledging that the land on which we gather here today is the traditional territory of the Wendat, the Anishinaabe, the Haudenosaunee, Métis, and the Mississaugas of the Credit First Nation. These nations continue to experience ongoing colonization and displacement, and today Toronto is covered by Treaty 13 and the Williams Treaties. Dying with Dignity Canada is also mindful of the broken treaties that occurred across Turtle Island and recognize our responsibility as treaty people to engage in a continuous process of both truth and reconciliation with all people across the land. I am thrilled to welcome you today. Through our webinars, we aim to provide you with information and key takeaways, as well as to create a space for conversation around end-of-life topics alongside the professionals that know it best. Before I welcome today's speaker, I'd like to go over just a few brief housekeeping items. Everyone on the call today is muted. However, there will be an opportunity to submit your questions. To do so, please type your questions into the question bar on the Zoom side panel, and we can read them out for you at the end. Please try to keep your questions as concise and clear as possible. While we are going to try to get to as many audience questions as possible, unfortunately, we may not be able to get to everyone today. If you have an outstanding question or a question that is personal in nature, please email us at support@dyingwithdignity.ca and we will follow up with you. The session will be recorded. There will also be a post-webinar survey that will pop up on your screen at the end of the webinar and will give you the opportunity to share your feedback. And now to introduce today's speaker, we have Jocelyn Downie. Jocelyn is a professor emeritus in the faculties of law and medicine at Dalhousie University. Her work on end-of-life law and policy includes special advisor to the Canadian Senate Committee on Euthanasia and Assisted Suicide, author of Dying Justice, a case for the decriminalizing euthanasia and assisted suicide in Canada, a member of the Royal Society of Canada's expert panel on end-of-life decision-making and the plaintiff's legal team in Carter v. Canada Attorney General, the Provincial Territorial Expert Advisory Group on Physician-Assisted Dying, and the Canadian Council of Academies expert panel on medical assistance in dying, and most recently, the MAID Practice Standard Task Group. She is a fellow of both the Royal Society of Canada and the Canadian Academy of Health Sciences, and she was named a member of the Order of Canada, in part in recognition for her work advocating for high-quality end-of-life care. Thank you so much to Jocelyn for joining us today. And now I will pass it off to Kelsey to get us started with the interview.
Thanks so much, Taylor, for the introduction. And thank you, Jocelyn, for being with us this afternoon. It's such an important day, and I'm so glad that you're here to recognize it and reflect with us.
I'm very grateful to be here with Dying with Dignity Canada today. It's very fitting.
Absolutely. So we're going to dive right in. We have a lot of questions, a lot of ground to cover, both reflecting back 10 years prior to today and reflecting on some of what's happened since. So we'll start first with the Carter case. This is a case that many people might have been there and might remember right now as we talk about it, but other people might be a little less familiar with the details of that case. So I'm wondering if you could start by sharing a bit about what the case was, who the plaintiffs were involved, and just some background information to get us started.
Sure. So the Carter case is the case that gave us medical assistance in dying, which we all call now MAID, gave us MAID in Canada. And at the center of the case, you have Kay Carter. So that's the name. Carter is associated with that. It actually wasn't Kay, whose name was in the list, but it doesn't matter. Kay was at the heart of it. Kay was an 89-year-old woman with severe spinal stenosis. She was in incredible pain, a degenerative condition. And she asked her daughter and son-in-law to take her to Switzerland so that she could access an assisted death because it wasn't legal in Canada. And they did that. And then they came back to Canada and they were inspired to fight for changes to the law so that people in Kay's circumstance and other people who are experiencing intolerable suffering wouldn't have to do what she did, which is be completely dislocated and go to Switzerland. And also there are many people who couldn't go to Switzerland, and so that they would be able to have access to MAID. There was also Gloria Taylor. She's a really important figure in this. She's a woman with ALS, which is a degenerative neurological condition. It's actually what Sue Rodriguez, who actually launched all of this years before, had as well. And Gloria joined the case and wanted to advocate for her right to have an assisted death at the time of her choosing. It wasn't at the time that she joined the case. She didn't want to die then, but she wanted to know that when her condition got to the point that she felt her life was no longer worth living to her, that she would have access to assisted dying. And I don't want to read anything today but this one thing. So I'm just wondering if I just want to read something from Gloria so that she's in the room. The people this was all about are in the room, and it's through her voice that people can understand what this case was about. So I'm just going to read what she said. I do not want my life to end violently. I do not want my mode of death to be traumatic for my family members. I want the legal right to die peacefully at the time of my own choosing in the embrace of my family and friends. I know that I am dying, but I am far from depressed. I have some downtime. That is part and parcel of the experience of knowing that you are terminal. But there's still a lot of good in my life. There are still things like special times with my granddaughter and family that bring me extreme joy. I will not waste any of my remaining time being depressed. I intend to get every bit of happiness I can wring from what is left of my life, so long as it remains a life of quality. But I do not want to live a life without quality. There will come a time when I will know that enough is enough. I cannot say precisely when that time will be. It is not a question of when I can't walk or when I can't talk. There's no preset trigger moment. I just know that globally there will be some point in time when I will be able to say, this is it. This is the point where life is just not worthwhile. When that time comes, I want to be able to call my family together, tell them of my decision, say a dignified goodbye, and obtain final closure for me and for them. My present quality of life is impaired by the fact that I am unable to say for certain that I will have the right to ask for physician-assisted dying when enough is enough, when that moment arrives. I live in apprehension that my death will be slow, difficult, unpleasant, painful, undignified, and inconsistent with the values and principles I have tried to live by. Finally, what I fear is a death that negates as opposed to concludes my life. I do not want to die slowly, piece by piece. I do not want to waste away unconscious in a hospital bed. I do not want to die racked with pain. So those are Gloria's words. That's why she was at the heart with Kay Carter and Kay's family. The heart of the Carter case. That's what we fought for, and that's what 10 years ago we got her wish.
I'm so glad that you shared her words with us today and with the audience. It's nice to be able to bring it all back to those individuals who were the ones really moving this issue forward, and with people like you, Jocelyn, supporting them all along that journey. So thank you so much for that. So this case focused on the Charter of Rights and Freedoms. That's something that consistently has been brought up during the case and since, with various other issues related to medical assistance and dying in this country. Can you speak to the applicable sections of the charter that tie into MAID here in Canada?
Yeah. So 2 sections in terms of rights were at play. So Section 7 is the right not to be deprived of life, liberty, and security of the person, except in accordance with the principles of fundamental justice. This will sort of become clearer as we go. It's a mouthful, but it's fundamentally the right to life, liberty, and security of the person. And then Section 15 is the equality provision of the Canadian Charter, which guarantees that you will not be discriminated against by the state on the basis of a host of different features. What's most important in the context of MAID is disability, that you won't be discriminated against on the basis of disability. So both of those are obviously at play when you have an absolute prohibition on maid. And so those were argued. The other section, though, that I need to explain is section 1, because in the Canadian Charter, what we say is you can limit rights. If you limit a right, if it's demonstrably justified in a free and democratic society, that legislation can be saved. So the government would be allowed to limit Section 15, for instance, have an equality breach, as long as it could demonstrably justify in a free and democratic society that limit. And the way you do that in part is, for instance, showing, okay, we have limited this right, but we had to, because it was the only way we could accomplish this other big and important objective. So you have to do this. We did 3-part analysis. You have to do the section 7. Is there a breach? And if so, is it in accordance with the principles of fundamental justice? Is there discrimination on the basis of disability? If you have either and or 7 and 15, is it demonstrably justified in a free and democratic society? So that's what's been at the heart of, that was at the heart of Carter, and it's been at the heart of the cases that we've had to go through since then.
Thank you. That really helps to clarify what that process looked like and what those arguments looked like at the heart of this case. So the next question is about where we ended up with the Carter case, what the outcome was. And spoiler to everyone on the call, I think we know we had a very positive outcome, which is why today is such an important day for reflection as to how far we've come in the past 10 years. But Jocelyn, could you share a little bit more about the Supreme Court's decision, what their rationale was for coming to that decision, and what things look like in that regard?
Right. So the first really important thing to say about the decision, what they did, was they issued a decision from the court. So it was unanimous, and we have a number of unanimous decisions, and then they list the name of the judge who wrote the decision and then everybody else who agreed with it. But when they want to put a cherry on the top of the sundae of a unanimous decision, they say it's the court. That is just making a statement about how united they were in the decision, in a decision like this. So we open up the decision and there it is, the court, which is quite extraordinary. Then in terms of the substance of the decision, so they looked at section 7, right to life, liberty, and security of the person, except in accordance with the principles of fundamental justice. And they found actually the right to life was violated, as well as liberty and security of the person. Life might surprise people because you're sort of like, oh, wait, you're talking about assisted dying. How is the right to life violated? Well, here's how it works. What they recognized is that people would die sooner than they otherwise would if we had assisted dying, because they would end their life by suicide before they could get into a state that they couldn't do it themselves. And that was a breach of the right to life. Security of the person, liberty, that's easier for people to understand because here is a decision of the most profound personal significance, and you're being told you can't make it. What is more significant than life and death, literally? And the state is telling you you're not allowed to make that decision. So that means, okay, there's the breach of the right. And then they have to look to this principles of fundamental justice, because you can limit that right as long as you do it in accordance with the principles of fundamental justice. And the key principles here were overbreadth and gross disproportionality. And those were, the analysis was, look, you're trying to protect vulnerable people from ending their life by suicide in a vulnerable state, but you've put this blanket prohibition out there. Nobody can have access to assisted dying. And they said, actually, so you've overreached. You could protect this group without preventing all of these people from accessing MAID. And then gross disproportionality is that the benefit you're getting from the restriction, this total ban, is actually way out of proportion to the harms that are being done, the harmful effects of the prohibition. And they recognized that, in fact, the state could, through a regulated system of MAID, achieve its goals and allow some people to have access. So therefore, it was not in accordance with the principles of fundamental justice. And then because they'd already decided that it was a Section 7 breach, they actually didn't go on to decide the equality argument because they didn't need to, right? Section 7 is already violated. They said, we don't need to go there. We're just going to go to say, oh, is this demonstrably justified in a free and democratic society? And they went through the analysis and the test that's associated with that provision. And they said, no, it's not, because it failed this piece of the test, which is the minimal impairment test, part of the test, which says it's related. That'll sound very familiar to what I just said about overbreadth and gross disproportionality. And it is slightly different, and it's a different part, and they have to do the analysis. And again, it is saying, well, did you impair the rights, the Section 7 right, as little as needed to achieve your goals? And the answer was, again, no. We can look to the Netherlands, we can look to Oregon, we can see that the healthcare system could respond if you allowed people who had a grievous and irremediable medical condition and are experiencing enduring and intolerable suffering, and you situated it within our very regulated healthcare system, you could give those people access without putting any of these other people at risk. And therefore, your total ban is unconstitutional. So they struck it down. So they say it is invalid insofar as it prevents people who meet those criteria from accessing MAID. And then it said, we recognize this is a big change. And so we're going to, it's called a suspension of a declaration of invalidity. So we declare it invalid, but we suspend the effect of that for a year to give the government time to, if it wants to legislate, it didn't have to, but if it wants to, it has time to do that. So they did that suspension of the declaration of invalidity. So that's how they said, we're not deciding 15. It is a Section 7 violation. It's not saved by Section 1. Bottom line, you just went too far. The blanket prohibition is not necessary in order to protect the people you say need protection. Therefore, you must allow it for this subgroup of people.
Thank you. And that's so powerful what you started your answer with about how the court signed off on this decision. I think that's maybe something that a lot of folks were aware of or maybe didn't remember from back when this happened. And it's just such a powerful reminder of how impactful this decision is. They sort of signed it off in the most meaningful way they really could have. So very, very interesting. Mm-hmm. So we're going to get into the details of Carter a little bit more and what happened after. But before we do, and you touched on this, and I think it's really important that we don't lose sight of this really important part of this history and this very impactful person, and that is Sue Rodriguez. So this isn't the first time we've seen a court challenge go to the Supreme Court about assisted dying. We did have a court case back in the early 90s with Rodriguez. Can you speak to the nature of that case and the result of that case? And of course, it was different than the result we had 10 years ago. But can you also share with us why you think there was such a difference between the outcome in Rodriguez and the outcome that we saw in Carter?
Yeah, so when I described Sue Rodriguez, she is a woman who had ALS. 5 minutes ago, how did I describe Gloria Taylor? She's a woman who had ALS. Sue Rodriguez went to court arguing that the absolute prohibition on assisted dying violated her Section 7 and Section 15 rights. So too did Gloria Taylor. But Sue Rodriguez lost in court. What happened? I mean, one of the things to note, picking up on your point about how important the court statement, the unanimity of the court in Carter, was the Rodriguez decision at the Supreme Court of Canada was 5-4. It was as close as you could get. And yet, a number of years later, it was unanimous in the opposite direction. So you could ask what happened. That would be reasonable. And I would say two things happened over the course of that time. The first is that the facts on the ground changed and the jurisprudence changed. So the principles of fundamental justice changed. And so that's why we were able to do this. I can go into this in more detail in a bit if you want. So let me just circle back to Sue and the case. So she had ALS. She made those arguments. It was a 5-4 decision against her. It is important for people to know Sue Rodriguez did die as a result of an assisted death. She was assisted by a physician, but the identity of the physician was never known to the state. And so nobody was ever charged in her case. So, we can, in some senses, those who support her feel comfort in the fact that she did get an assisted death, even though she lost in court. And it's also really important to acknowledge her legacy, right? Her call for respect for autonomy and choice, as you titled this session, it resonated for many, many years. Her words ring out and did over the decades and through the Carter case. She famously said, "Who owns this life? Whose body is this anyway?" And that carried the advocacy over the years, and it wasn't heard in one sense in the Rodriguez decision, and yet it was at the heart of the Carter decision.
Thank you so much for that, Jocelyn. So we're going to move on to implementation of the first assisted dying law that we had federally in Canada. You mentioned a moment ago that things were kind of put on hold for a year. The government was given the option to legislate if they wanted to, but they didn't have to. Ultimately, there was a decision to write a law, and there was a bit of a delay, so that 12 months turned into 16.
Yeah.
Can you speak a little bit to that and what was happening in those 16 months between the court decision and the legislation coming into effect?
Yeah. So some people were actually able to access MAID in that period. The court gave Gloria Taylor the ability to go to court if at any point during that time, the 12 years turned into 16, she was eligible for MAID, she could go to court and get authorized for it. Then they extended that to everybody once the government took too long and came back seeking an extension. So for a period of time, you could go to court and seek a judicial authorization. Not a lot of people had it, but it was there. But what was going on was clinicians, a group of clinicians, took it upon themselves to go over to the Netherlands, get trained in how to provide this health service that nobody in Canada had ever provided before. And they came back and they helped train others, and they developed protocols for what medications do we use, in what dosages, in what order, all those kinds of things. They reflected on assisted suicide, which had become so self-administered MAID and provider-administered MAID, and they came up with recommendations about what to do with that. So clinicians really stepped up. Who didn't step up is the government, and in fact, most regulators, because the provincial governments had a year. Did they do anything? No. They were waiting on the federal government, and the federal government was delaying and delaying. It had some legitimate reasons for delay, but also some not so legitimate reasons for delay. And so the governments didn't get the system ready. And that put the burden of implementation readiness on the clinicians. And we're really lucky that in Canada, we had a group of clinicians who were willing to take on that burden, and they did it very, very well and very responsibly. So in that period, you have the clinicians doing their thing, getting ready. Eventually, the government put in place Bill C-14, which took the absolute prohibition out and put in a regulatory framework for MAID for Canada. And that came into effect in June of 2016.
Thank you. I think this next question is I think the answer to this next question will be really important for folks to hear because this piece sometimes gets lost in the dialogue that we have going on around Made in Canada. And that's the difference between what we had in Carter, and you briefly touched on the wording that the Carter case included. But the difference between what we have with Carter and what was then put in place in C-14.
Mm-hmm. Excuse me. I remember the feeling that I had when I heard about the Carter decision. I also as vividly remember the feeling I had when I saw Bill C-14 for the first time and heard about it. I was in one of those sessions that the government will do right before they release legislation to brief people so that then you can be informed and go out and speak to the media and right away. And they described Bill C-14, which none of us had seen. Well, nobody I knew had seen. And I almost fell off my chair because Carter decision said you have to have a grievous and irremediable medical condition basically causing enduring and intolerable suffering that is unacceptable to you and in your circumstances. And what the government did was it said, okay, you have to have a grievous and irremediable medical condition, and we're going to define that in the criminal code. And they put 4 elements in. So you have to have a serious and incurable illness, disease, or disability. You must be in an advanced state of irreversible decline in capability. You have to be experiencing enduring and intolerable suffering that cannot be relieved by means acceptable to you, basically. And here's the kicker. This is where I almost fell off my chair. Natural death has to have become reasonably foreseeable. The first thing literally out of my mouth was, that's 100% of people. Our natural death is all reasonably foreseeable. It's certain. It's not just reasonably foreseeable. Of course, they didn't mean that, but it almost was foreshadowing of some of the problems with what they've done. At any rate, if you think about the Carter parameters, grievous and irremediable and intolerable suffering, and then you think about that definition of it, it shrinks. If I draw a Venn diagram, one's inside the other. It shrinks because natural death has become reasonably foreseeable is more restrictive than what the Supreme Court of Canada gave us in Carter. And we basically, foreshadowing what we're going to talk about as what then happened. We've been fighting ever since to keep this sort of this back and forth. But it's super important for people to understand that that's what happened, that C-14 shrunk. So when subsequently C-4, that piece, natural death has become reasonably foreseeable, gets struck out, we'll come to that, and it goes back out, it's gone. We didn't expand. So people some opponents like to say, Canada just has been expanding. And we haven't expanded at all. We started with Carter, shrank, go to Carter. That's not expansion. And that's one thing that critically important happened, that the natural death reasonably foreseeable. And the other is, and this, again, we'll come to this, I'm sure, is the issue of mental illness and where mental illness is a sole underlying medical condition. People talk as if when we get there and we have it, we will again have expanded, Canada's expanded. It was not excluded in Carter. It was clearly not excluded in Carter. We know that because, remember, I mentioned some people could go to court. Well, one of the people who went to court and got authorized had mental illness as a sole underlying condition, and that was under the Carter criteria. So we know that. So that's what happened was C-14. It put in place a bunch of procedural safeguards, which are crucially important. Eligibility criteria, crucially important. No denying that. It's a solid regime, except for the fact that they shrunk the eligibility criteria, which meant that, in my mind, it was not charter compliant and it was not Carter compliant.
Absolutely. Yeah, I think that's so important for folks to know. This is not an expansion. It's a working back to where we should have been all along. But unfortunately, the law wasn't reflective of that reality. So great. Thank you so much. And we're going to loop back to the reasonably foreseeable piece because it's a big one to unpack. There's been a lot going on to try to get us to a better place with that. And fortunately, we've had some cases that have been instrumental in getting us there. So Lam and Trushan, I'm hoping you can provide a bit of an overview of those cases and where they ended up.
Sure. So picture C14 comes out in June. It's got natural death has become reasonably foreseeable. We're reading it, the Carter team, the legal team in Carter, we read it. The lead lawyer, Joe Arve, was a brilliant constitutional lawyer who died unexpectedly and prematurely. Immediately, within 10 days, was back in court. He read it and he's like, this is not consistent with the Carter. It's not consistent with the charter. We're back in court 10 days later, representing Julia Lamb. And Julia was a young woman in British Columbia. She has a progressive degenerative condition. And she felt that this narrowing of Carter would preclude her from having access to MAID because was her natural death reasonably foreseeable. She had a disability. Her condition would become intolerable at a point at which she might still have years, decades to live. And so she felt that was a breach of her charter rights. So Joe and the team were back in court, as I say, within 10 days. As it turns out, that case was adjourned because what happened was the government expert weighed in and said, oh, no, Julia could qualify under C14 because if she indicated that she was no longer going to use her BiPAP machine, which is like a sleep apnea, and she doesn't have sleep apnea, but it's like that. It helps you breathe at night. If she indicated she wasn't going to use that, then she would get pneumonia. And if she indicated she was going to refuse treatment for pneumonia, then she would die. So her natural death is reasonably foreseeable. This is a bit of a shocker to come from the government expert. It was a very expansive read of natural death is reasonably foreseeable. But because they put it in, the government put it in, it was their expert, they were conceding this is the case. So the case was adjourned because she didn't need, they were saying you're eligible when you get to the point where you want it. So that case was adjourned. Meanwhile, across the country, in Quebec, you have Truchon Gladu. So Jean-Pierre Ménard, a brilliant health lawyer in Quebec who has taken many very important cases, he represented Nicole Gladu and Jean Truchon in the fight against natural death has become reasonably foreseeable. And tangent here for one quick second, there was legislation in Quebec on MAID before the federal legislation. I can explain it in questions if people want to know more about it, but the bottom line, the key for us for our discussion here in my little asterisk tangent is that their criteria was end of life. You had to be at the end of life. So Nicole Gladu and Jean Truchon were challenging both the end of life in the Quebec and natural deaths reasonably foreseeable in the federal legislation. Nicole Gladu had post-polio syndrome, and Jean Truchon had cerebral palsy, advanced cerebral palsy. And so they both were arguing that natural death reasonably foreseeable, end of life, discriminate against them on the basis of physical disability. They were not eligible for MAID, and yet their suffering would become intolerable. And at the point at which it became intolerable, they wanted to have access to MAID. So again, we were running Section 7, Section 15, Section 1 of the Charter, arguing that it's a breach of the right to life, liberty, and security of the person. It's a breach of equality, can't be saved under Section 1 because you can allow people in the circumstances of Nicole Gladu and Jean Truchon to have access and still protect the people that you are saying the prohibition is to protect. So Justice Christine Baudouin struck down both provisions, the natural death reasonably foreseeable and at the end of life. She also did the suspended declaration of invalidity to give the government time to cope with this. And the government decided not to appeal on the grounds, and this is also really important because people obfuscate this, on the grounds that it was a very strong decision. So they were supporting the analysis and the decision, and they said they would lose on appeal. So there was no point putting everybody through, including Nicole Gladu and Jean Truchon, everybody else, all the other people who would be waiting, through that, waiting for this to go through the Court of Appeal in Quebec and then up to the Supreme Court of Canada. They would accept the decision and amend the law. So that was the end of it. People turned to the process. Okay, how do we amend the law? Then an election, COVID, all different things happened. So it got extended. We ended up with the extraordinary expression of an extension on an extension on a suspension of a declaration of invalidity. It was just candy for constitutional lawyers. And it was horrible for the people who were involved, because it was just delay after delay after delay in getting the legislation, because what would happen is they would get it extended by the court, which would mean it couldn't come into force yet. So again, what happened though is that they at first, it was right from the get-go, Nicole Gladue and Jean Trichon were able to have access. They would go to court and they'd be allowed to have access. Then with the delays, it got expanded so that if you were eligible, if you could meet the terms, you could go to court and seek judicial authorization. And then it went even further, because I think the government was so embarrassed by how long it was taking. They actually undertook to pay the court costs for people who needed to go to court for authorization. Because, of course, regular folk can't really afford to go to court. It's incredibly expensive, even if your lawyers are pro bono, right? Even if your lawyers are working for free, it's still very expensive to go to court. So they even agreed to pay for that, for part of that window. And so then the window finally came to an end. They introduced Bill C7, which took out natural death reasonably foreseeable, but made me fall off my chair again by introducing the exclusion on mental illness. So they reflected. So Carter, C14, back out with Trichon, and then I assume we'll talk about C7 when it shrinks back down, but not by so much.
Thank you for that. I think that point you made about the government choosing not to appeal and knowing they lose on appeal, and that there's speaking to the real strength of that case. So important for people to know that and reflect on that, and how this change really needed to happen, right? There was no doubt that C14 wasn't meeting what Carter had set out. So so glad you mentioned that.
And really important to note here, a picture for a tip of the hat to the judges at the trial level. We had Justice Lynn Smith in Carter and Christine Baudouin in Trichon. And I urge people, you need a lot of time because they're both long decisions, but I urge people to read the decisions, because what that will give you is a profound sense of comfort, I think, in how seriously this was taken, how carefully the evidence was introduced, tested, reflected upon by these judges, and the thoughtfulness and rigor of their decisions is truly extraordinary. And of course, it's at trial when all the evidence is fully described and discussed in the decision. It's not at the Supreme Court of Canada level. It's more summary form. So that's why those two decisions are really important for people to read, to understand how did we come to someone striking down the whole prohibition, and then how do we come to somebody striking out natural deaths reasonably foreseeable. These are serious, thoughtful, rigorous decisions.
I think that's what we've seen too, just the nature of MAID in general, from the legal teams and the judges working on these cases to the clinicians who are providing MAID and meeting with patients and assessing them, just how careful, how thorough everyone is in this work. And that seems to be a theme we've really seen over the years.
Mm-hmm.
So you mentioned the mental illness piece, and we certainly had that on our list for today. I think we had it down the list a little, but I don't want to lose sight of that, especially for our audience. I love to keep that thread going.
Okay.
So could you speak to that? What's going on with MAID and mental illness, the piece that was included in C7 that was shocking when you saw that, and just what is the current status of that issue?
Right. So we open up C7, and there's this little line. So remember, we had the eligibility criteria. You have to have a serious and incurable illness, disease, or disability. There's this little almost asterisk which says A mental illness is not a serious and incurable illness, disease, or disability for the purposes of this legislation. The shock of that, in one sense, the shock is a global shock of what does that say to people who are experiencing mental illness, to see the state say a mental illness is not a serious and incurable illness, disease, or disability. I get that it's restricted to the context of MAID, but it's a statement that people can feel hit by at a more general level. But to the specifics, so they introduced this exclusion, and it's just saying mental illness. So if you think about it, if mental illness is not a serious and incurable illness, and disease, or disability, that means if mental illness is your sole underlying medical condition, you can't have MAID. You're ineligible for MAID. And so the immediate response to that was, this is unconstitutional. This is inconsistent with Carter. This is inconsistent with the Charter. So there was immediate pushback. And what happened was the Senate then amended the bill. It had come in with just this is excluded forever. And the Senate amended the bill to introduce what we call now the sunset clause, which says this provision, the exclusion, will be automatically repealed in however long. Why I say however long is because the Senate put one set of time. The House sent it back with a longer time. It ended up being passed with 2 years. So it was, this is in, the rationale being, give us time to get ready. And in 2 years, it'll automatically be repealed. Well, fast forward 2 years. Oh, no, we're still not ready. We need an extension of a year. Okay, they get that passes in Parliament. Time passes. They come back and they say, oh, we need 3 years. So we're now talking 2027, exclusion to 2027. And so, that's 6 years just of the delay. But it's actually really important for people to remember what we talked about a few minutes ago, which is Carter didn't exclude mental illness, which means it's actually delayed since Carter. And here we are at the 10th anniversary. So that's what happened. What's going on now is, after 3 iterations of trying to get Parliament not to do this, there's litigation, because that seems to be the only way we get progress on MAID in Canada, is with a couple of exceptions, and Quebec being a huge exception, but for the rest of us. And so back in court. So 2 very brave individuals have put their names forward to be the lead plaintiffs in the case of Brosseau and Scully versus Attorney General of Canada, arguing that the mental illness sole underlying condition is a breach of their charter rights. Dying with Dignity Canada is in place as a public interest plaintiff, helping to support, because with this kind of case, you need to have an institutional entity that can support the case and be there. For instance, as we had to have happen in Carter, if people die before the case is finally heard, you want somebody there, and so on. And so Dying with Dignity Canada is involved in this case. And so we have the 2 individuals, and we also have a physician who is arguing that her rights are violated because it's what's called void for vagueness. Mental illness is the exclusion, yet that is not a term that clinicians use or know what it means. Mental disorder is used, but it's very clear the government was not including all mental disorders. They said so. They said it's not neurodegenerative, it's not dementia, it's not. And so they mean something less than mental disorders, but we don't know what mental illness means. It's not defined. And one of the rules of the justice system is that an individual cannot be put at risk of imprisonment. And if you breach the MAID laws, it's serious imprisonment, without being able to tell where are the boundaries beyond which I'm allowed to step. And you also have to have it so that the law is written in a way that police and prosecutors and judges also know what the boundaries are. And the argument is, we can't know what it is because mental illness is not a word that anybody knows what it means. So the principal argument is violation of the charter for the plaintiffs. That's true. Not principal argument, but that's the one that keeps everybody staying up late at night working on the case. But we also have the void for vagueness problem, which is a severe flaw. It's a fatal flaw, I think, in the legislation. So where are we with the case? Case has been filed. The government has not yet responded. So this is going to take a while. I'm learning. Carter was sort of fast compared to what's happening with the litigation we're seeing now. Truchon was very quick, but it'll take a while. But that's active at the moment is to try and what that would do is, again, and we go back to our side, Carter, C14, Truchon, C7, and now Rousseau and Scully, hopefully, if we win, will take us back out to Carter. 10 years of trying to get us back to Carter.
Well, thank you for the update on that issue and all the work that you're doing to support and sharing with everybody where that specific challenge is. We are going to talk about some other challenges and barriers that still exist despite the last 10 years and everything that's happened. But before we do, I just wanted to touch on other changes that we saw as a result of Truchon. The removal of reasonably foreseeable natural death requirement was the biggest one and the one that we often think of most, but there were some other changes, positive mostly, too, that I was hoping you could touch on today.
Yes, there were. This is the good news part of the history. One matters a lot. It may seem not so significant to people, but there used to be a requirement of 2 witnesses to the request, and that was dropped to 1 because people, the government came across the country, did a big consultation, give them credit for that, and listened and heard what people were saying. What are the barriers to access? And one of them was this 2 witness requirement. And Dying with Dignity Canada actually really stepped up into this space when this happened, because there are a lot of people who don't have family. They don't have anyone who can act as a witness for them. Some institutions were saying any of their staff weren't allowed to be a witness. So if you're in a facility that nobody's allowed to be a witness and you don't have any family or friends who are coming to see you, there's a barrier. So Dying with Dignity Canada actually stepped in and trained witnesses, and they were all across the country. They were driving all over, serving that function, which was great, but it was really hard. And so the government was recognizing you don't need 2. This is making sure the person who's signing it is the person who is making the request. One is quite enough. So that got fixed. The really big one was final consent waivers, what we call final consent waivers now, came about as a result of what we call Audrey's Amendment. So Audrey Parker was a Nova Scotian woman, and she had breast cancer that had gone to her brain. She was eligible for MAID. She met all the requirements, but she wanted, this was the fall, she wanted to try to live through the Christmas holiday season and New Year's. It's her favorite time of year. She wanted one final holiday season, but she was at risk of losing capacity. And the thing about the law as it was structured at the time is you have to make a request. You have to be capable at the time of the request, but also immediately prior to the provision, the clinician needs to say to you, do you want this? Are you consenting to me providing with MAID? And you have to have decision-making capacity. So if between the time of being found eligible and making a request and the moment of the provision, you lose capacity, you lose access to MAID. And so she was concerned that if she waited over that period, she might lose decision-making capacity. And so then she would lose her access to MAID. So as a result, she died as a result of MAID on November 1st of the year in which this was all happening. She was very public about this. She made a plea, many pleas, to the government to change the law so that people like her would not be caught and have to die earlier than they wanted. Echoes of the violation of the right to life in Carter. She had to die earlier than she wanted to avoid getting caught in that predicament of unexpectedly losing capacity. So what they did was, it's not full advance requests. And that we've got to be really clear on that, because you have to have met all of the eligibility criteria for MAID. in order to do what's called a final consent waiver. So you have grievous and irremediable medical condition, and you must be experiencing enduring and intolerable suffering at that time. Then you can do a final consent waiver, which says, so Audrey, what she would have done, for instance, is she would have said, okay, I'm fully eligible and consent. Now we will make an agreement, you, me, and my provider, that January 8th, I will have MAID. And if I lose capacity between now and then, decision-making capacity, you will give me MAID on or before that date, so that she was protected. If she was still capable on January 8th, she wasn't getting MAID. I mean, not through a final consent waiver, they would have a conversation about it. But if she had lost capacity, she was guaranteed that she could have access to MAID. So that was the change they made in C7. And that is one where I will give the government credit for that didn't come about through litigation. It came about through advocacy, but also through the government having these consultations and listening and saying, oh, you know what, that was an unintended consequence of the way we wrote this. Yeah, no, you're right, we should amend it. And they did. So credit to them. That has given an enormous amount of comfort to many, many people. And they also live longer because they know, okay, I'll keep going because I know I'm not going to lose my chance at this, and I'm not going to linger in a state I don't want to be in for months or years as a result of losing decision-making capacity.
Thank you for that summary, and love to see the good news piece and the positive outcome there. Yeah. We do have a ways to go though, and you alluded to this, that this is a different thing. We have waivers. What we don't have, in most of the country at least, is advanced requests for MAID. But can you share with us where we're at with that? The good news we did see in one part of the country, at least late last year, and where that specific issue is at this moment in time.
Right. So, yep, the good news destination is Quebec. So what Quebec did was it amended its legislation, its MAID legislation, to allow for what we call advanced requests. So before you're in a state of intolerable suffering, but it still is after you have your diagnosis with a serious and incurable illness, disease or disability that will threaten your capacity, but it's before the suffering. So I might get a diagnosis of dementia, but before I'm experiencing intolerable suffering, I can have an advance request in which I write down the circumstances in which, after my loss of capacity, I want to receive MAID. I do that with a clinician, with my provider, and that then goes into a registry, a provincial registry. I'll also note you do it on one form. It is an official government form. It's not going to be written on the back of napkins. It's not going to be written in people's wills. It is a single, very specialized form, and it will go into the registry, and then it can be acted upon in the future when you lose capacity. So that is something that 83% of Canadians want to have. At this point, whatever percent of Canadians is the population of Quebec, that's who has it. The rest of us, we don't have advance requests because of the requirement that you give express consent, you've met all the criteria. We can't get that. Will we get that? I mean, what's going on with it? Well, every expert panel that has looked at this issue has recommended to the government that they allow it. They sort of keep studying. And what they're doing right now, literally this week, last week, is having an extensive consultation across the country on this issue. So they're hearing from Canadians, they're hearing from experts, clinicians, regulators, everybody, about what might it look like, what if we were doing this, what would we do, and should we do it? So they're doing that consultation now, Health Canada. So they'll have the results of that before the election, I assume. But what will happen is largely dependent on the election, the inevitable election, because if the Conservative Party becomes the government, there is no way we are getting advance requests in the rest of Canada. If they don't, If it's, for instance, the Liberals and the Bloc, remember, Quebec has it. So the Bloc would support an advance request. Maybe it would go through. Maybe they would say, 83% of Canadians want this. Quebec has it. We can do this. We've done this consultation. We understand how to do it safely. We're going to do it. So the which path we end up on is a function of the next election.
For that, and of course, this is an issue all of us are following closely. If you're not receiving email updates from Dying with Dignity Canada, I encourage you to sign up for those as we learn more about this and other things related to MAID. We'll certainly be updating people. Before we, as we near the end, we're getting very close to the end of our time together, but before we start to wind down and wrap up, I did want to touch on one other barrier that, again, 10 years in, we're still seeing. We've seen since the very beginning, and that's issues related to forced transfers. Can you speak to what that means, what we've seen, and what's happening currently with forced transfers?
Right. So the thing people have to understand is that in Canada, there are publicly funded faith-based healthcare institutions, and in many but not all provinces and territories, they are allowed to refuse to allow MAID to happen within their walls. So we have the Hotel Dieu Hospital in Kingston, Ontario. It's a Catholic hospital. It doesn't allow MAID. You have St. Paul's Hospital in downtown Vancouver, Catholic hospital, does not allow MAID to happen within its walls, which leads to forced transfers, which means somebody is in St. Paul's and they want to have access to MAID. Initially, they wouldn't even allow assessments to happen, and people ended up having assessments out on the street in a bus shelter in the rain, so they changed that. But you must leave the hospital in order to access MAID. And people need to understand how excruciating that can be. In fact, it can be impossible, because there are circumstances in which it is just, you simply cannot be transferred. You will die in the ambulance, or the pain is way too extreme and can't be managed, so you can't be transferred. Or you can, but it will be incredibly painful, and you're transferred to another space in which somebody will provide you with MAID. And what also happens is it can be a barrier to access, because some people will say, okay, I know that St. Paul's doesn't allow MAID in the walls, so I'm not going to go to St. Paul's. It's the only place I can get the care I need and relieve my suffering, but I know I won't get MAID, so I'm going to have MAID now at home. Like, can you imagine? Because you want to preserve your ability to get MAID. There are also circumstances in which no transfer is possible. Like, how much transferring can happen within many of our cities? Like, it's not like there's empty beds everywhere. Right? We know that. And so there are just all kinds of ways in which this permission of publicly funded faith-based institution creates barriers to access to MAID for people and causes extreme harm. So, more litigation. So there's a team in British Columbia. It's actually in the firm that Joe Arve was with. So there's that sort of touches my heart. And so that pro bono legal team is taking on the BC government and Vancouver Coastal Health and Providence Care Health to say it's not acceptable for a publicly funded faith-based institution to refuse to allow somebody else. You don't even have to provide the clinicians, somebody else to come into the facility and provide MAID. And the plaintiffs in that case include Sam O'Neill, which some people will have seen her story because it was in the news a lot, maybe, I guess, almost a couple of years now. She was a young woman who had cancer, and she ended up in St. Paul's. It had been where she'd been getting care, and she ended up in St. Paul's, and she ended up wanting MAID. It was a brutal circumstance for her, and she had to undergo a transfer that was just horrific. They transferred her to a commode chair, and she was in incredible pain. In order to manage her pain, they were giving her more and more drugs in the ambulance, so much so that she actually lost capacity. She was unable then to have her final goodbye with her family in the alternate space. Just so cruel. And so Sam's family are the plaintiffs. Her executor is the plaintiff in this case. We also have a clinician, Jyoti Jairan, who is bravely taking this on, and she is a plaintiff as well because she is saying her conscience is violated by this because she's a clinician caring for a patient, and she has to participate in a forced transfer, which she believes is unethical according to her professional standards, and her own personal conscience. And so that's a breach of the charter as well. So that's being litigated in BC. What's interesting, Quebec is always this, except Quebec, asterisk. Quebec's the flip of it, because Quebec government took a position that no institution, if it's publicly funded, is allowed to refuse to allow MAID to be provided in their walls. And the Archbishop of Montreal is litigating. So the Archbishop of Montreal went to court and said, you should not, no, it's a violation for you to prevent us from exercising our freedom of religion. And that one is being litigated in Quebec. They had an initial flurry because they sought an injunction to prevent the government's ruling to take effect so that this one hospice would be allowed to not allow MAID. But the language in that injunction to me is very strong about patients. It recognized the harm of forced transfers and the harm of a lack of access, more broader than just forced transfers, this lack of access to care, to hospice. I don't get to go to hospice. I don't get hospice care because I want MAID, that kind of thing. It really emphasized the harms. So we don't have the trial decision. Obviously, it hasn't even gone to trial yet. But if I were, if the side I'm on, obviously, is that publicly funded faith-based institutions should not be allowed to do this. I take comfort in that decision because it is at least recognizing the harms that are done. There's another decision just to mention, again, give comfort, which is in Ontario, it's not institutional conscience, but clinician content, individual conscience. The College of Physicians and Surgeons of Ontario said clinicians have a duty of effective referral. So you can object. No clinician in Canada is ever forced to participate in MAID. We have to be super clear about that. But they have a duty to refer, make an effective referral to somebody who is willing to provide the care if the person is eligible. And that was challenged by the Christian Doctors and Dentists Association, but they lost. And the decision is very, very strong. The wording is very, very strong that the focus must be on the patient, on the patient's well-being. You cannot harm people in that way of not referring them to a willing provider. So again, another judgment that advances patients' rights and patients' well-being. But so Quebec and BC are the ones to watch on institutional obstruction of access to MAID. Those will take us some time. Our trial date is January 2026 in BC. We filed in May, January 26th. But that's litigation in our country. So those are being advanced. And one thing we're seeing, I would flag here, is not through litigation, but through advocacy, is hospices and palliative care units increasingly being open to MAID. So initially, there were a lot that were like, no, this is contrary to palliative care, this is contrary to hospice. And that is, I don't know, melting away, maybe too strong a word, but shifting as we have more palliative care clinicians who are themselves MAID assessors and providers, palliative care organizations that see MAID as just a part of end-of-life care for some people. And you have hospices which are allowing MAID within their walls. So that's something also to watch and be thankful for, and to remember when you think, oh, does advocacy ever work? Maybe we always just do need to be going to court. Sometimes I feel that way, but then I'm reminded that you get change through education, exposure as people often what happened people would say is like they saw one forced transfer and they're like, oh, never again. So they supported it, they thought that made sense, and then they see one and they're like, I cannot as a healthcare provider participate in the infliction of that kind of harm. So I think that's part two of why we're seeing that evolution. So I do still remain optimistic around that kind of grassroots evolution and impact of advocacy. I've pretty much given up on a parliament at the moment, and feel we need to be in court, but it's definitely worth engaging locally. I saw a hospice recently in Ontario, somewhere in Ontario. They changed. Local people wrote to the board and said, this is wrong. And the board listened and the board changed their policy. So be involved.
Yeah, it's good to see that those changes happening. I think it's, discouraging that we've seen forced transfers for the entire time we've had MAID. I remember a story also out of St. Paul's, a man named Ian, who his story was public in the media at that time, and comparing that to then what Sam went through many years later, and seeing those same harms. I'm glad that there's movement, of course, to try to fight this specific barrier. And thank you for the update on where everything is with that. So we are winding down. We have 8 minutes or so left before we wrap up. And one thing I really wanted to touch on, Jocelyn, is we've heard a lot about the Carter case and what's happened since, but I wanted to go back to that day and the years prior to it and get a little bit more about what your role was in that case. And also, I'm wondering if you could take us into that room where you were 10 years ago today and what it was like when you heard about this unanimous decision.
Yeah, it's been quite remarkable this week to be reflecting on that. You get so caught up in the today that I sometimes forget to look back, and it's actually been a really positive experience to look back. So my role, I was a member of the pro bono legal team in Carter with Joe Arbe, Allison Latimer, Sheila Tucker, and Grace Pastine. So it was 5 of us, which is quite extraordinary when you're up against the Attorney General of Canada and the Attorney General of BC. Well, tangent story, I was in a coffee shop once with somebody who was opposed to MAID and didn't know the role I'd played, and went into how incredibly unfair it was, the Carter case, because the AGs were up against this mountain of evidence, and this team, this must be a huge team that had been gathering all this evidence for years to just flood against the AG. I'm like, there were 5 of us. We were pro bono. No, we weren't doing it for years. I got involved in like February or something, and we were already putting in our evidence by some months later. There was none of that. It was just an incredible commitment by a small group of people who then were helped by a bigger group of people who were willing to bring their expertise to the court, to bring the empirical evidence from the Netherlands and Belgium and Oregon, and the philosophical arguments that were at the heart of the Section 7 analysis, and the experts were willing to work pro bono. And there's a difference, right? If you are an expert for the government, you get paid. If you're an expert for a pro bono legal team, we never have money. So we have to phone them and say, look, I'm an academic just like you, and I'm not getting paid for this. So will you do this for free? Anyway, so we were working day and night. For a time, I was in New Zealand, and Joe Arve was in Victoria, and our cycle was such with the time zones. I would stay up till I don't know how the time would work, but it'd be about 2 o'clock in the morning, and then he would be getting up at around 5, so we'd overlap for like 20 minutes. And then he'd work through the day, and then I'd wake up and all the things he'd sent for me to do would be there, and then I'd work through my day and send it off to him. For a time, it was like a 24-hour, because of the time zones, we were a 24-hour production unit. So it was wild. It was arduous. When you got tired, though, all you did was stop and think about Kay Carter and Gloria Taylor and Sue Rodriguez and all the others. And you're like, well, I can't be too tired to do this. Come on, go get a cup of coffee and get going. And everybody was like that. So we just worked as hard as we possibly could to put the best possible argument in front of the judge. One thing I would note is when I heard who the judge was, Ms. Lynn Smith. She's a former dean of law at UBC. She's a feminist constitutional legal scholar. And I remember thinking, okay, whether we win or lose, even if we lose, I can feel like this was totally fair. She will be rigorous, she will be fair. And that's all you can ask for this from a justice system. So that was really comforting. I had no idea what her views were, but I was comfortable saying that it wouldn't matter what her views were. She was going to follow the evidence and the law and come up with whatever she came up with. So that was another little piece of the story that is, I think, really important. So that was the experience. The day of, so I was here in Halifax, and I was in my dining room. I had my phone and my iPad and my laptop all open at different sites. In case, where was it going to come up first? We knew when it was coming out because they're scheduled, and part of the team was in the room together with the decision, because you get the decision embargoed before it is released to the public. And the moment when they called, so I'm on the phone, I can hear Lee and Hollis and others in the room just elated because we'd won and it was the court and everybody was relieved and excited and happy. And all of my phone explodes, my messages explode, my email explodes. I get off the phone and jump into the decision and start reading. And I know the first thing that struck me, I'm reading, and it was held the court. And that hit me really hard. And then it was that the absolute prohibition was of no force and effect. And you see that right away, right? And then the first paragraph ended with them describing what was in front of people like Gloria, that with this absolute prohibition in place, they had to either end their life by violent or traumatic means, suicide, or suffer intolerably for perhaps years. And the words that I will never forget are, "This choice is cruel." At which point that, not only did you win on the law, but on a human level, they understood what this decision was about. It was about autonomy for people, so it was their choice. And it was about preventing a situation which was profoundly cruel, which was the suffering. And so, it only took me to get through that paragraph to have this profound sense of relief, joy, comfort, happiness for the people who were going to be benefited by it. And the relief that I knew people across the country would be feeling who were in a situation where they were precluded, they were prohibited at the moment, but once this decision took effect, they would have a way out if it got to be too bad. That's the thing that's also really important for people to remember about MAID, is like it helps the people, the 60,000 people who've had MAID so far, but it also helps their family and friends who don't go through a traumatic dying experience with their loved one watching that. And then it's an iceberg, because underneath the 60,000 is the hundreds of thousands of people who are comforted by knowing that it's available if it gets to that. So, imagine you're reading a decision that does that. And so I just sort of sat with it and in sort of a slightly stunned silence for some time. And I was grateful for our legal system that it was able to do that. And I look at other countries where they don't have a charter. They don't have the arguments available to them that we have had. And so they have to go about it in a different way, which is through legislative bodies. And that ends up being necessarily, the smallest possible access, because you have to horse trade to get enough people to vote for it. Whereas our system is grounded in human rights. That motivates it, it circumscribes it, and that is what it should be. And ours is.
Thank you so much, Jocelyn, for sharing that with us. And I think it's just so powerful to reflect on a case like this one that's really, in many of our lifetimes, we're not going to see a case that's having that iceberg effect, as you mentioned, that's bringing comfort to so many and changing the lives of so many who are choosing at that moment to have the ultimate, form of autonomy over their death and really live their values as fully as possible in those final moments. So thank you so much for sharing that with us. Thank you for being here today. It's wonderful to see you as always, and especially to reflect on this court decision. We do have a comment from our audience, and I just wanted to share it with you. This person says, "Thank you, Jocelyn, for all your dedication and hard work. It is good to know that people like you in the world are helping us all." And on behalf of Dying with Dignity Canada, we want to echo that lovely comment, as I'm sure many of our audience members do today. Thanks for joining us, audience members who are watching. We appreciate you being here today, and we wanted to let you know that thanks to the generosity of our supporters, we provide webinars like this and all of our quality and compassionate services 100% free of charge to people all across Canada. If you do want to consider paying it forward today and making a donation, the link to do that has been put in the chat. And we will leave it there for this afternoon. Thanks again, Jocelyn. Thanks for everyone for being here. And I hope you all have a pleasant afternoon.
Thanks, Kelsey.